the Constitution and statutes and so forth. That really provides the backbone from which, the skeleton from which then we build society. And I was very attracted to the idea of studying it. So decided to go to law school, and I got a full scholarship to Notre Dame, which is where I began my law career and where I met my husband.
And tell us about the clerkships. Both Justices Silberman and Scalia were hugely influential figures. What did you learn from them?
Yeah, so a clerkship is like a postdoc for young lawyers, or you can think of it as an internship, but once you've already got your law degree. And you have a chance to study with someone who is very accomplished and really excellent lawyer and work at their side. And it's a coveted job because there aren't very many of them. Each judge can just hire a few. So Judge Silberman had 3 law clerks and Justice Scalia had 4. And I spent 1 year with each, and you help them with cases from soup to nuts, from the time the briefs are filed to sitting through the arguments, to advising them, helping them do the research, producing first drafts that then they take and redo. So it was an incredible experience. I learned how to think about the law in a deep way. I learned about how to think about judging and the role of judging and neutrality in judging, the challenges of putting theories about the law into practice, watching collegiality at play in a multi-member court. So they were very formative years.
Lots of great stories. The clerks would figure out who was supposed to ask Justice Scalia to lunch. He loved to take you to AV's, an old Italian restaurant, to sing boisterously while he was writing opinions. You said he had a good voice. He was also, for you, a model for how to live.
He was. He was all of those things. He was brilliant. I think a lot of people are familiar with his quick wit and his pen. He was an excellent writer. He was a teacher, too. I think one thing that inspired me to write this book is that Justice Scalia, even off the bench, tried to bring the Constitution and the court and law to people, lawyers and non-lawyers alike. He certainly mentored us in chambers, but then he also, I think, really taught a lot of people and engaged a lot of people in law and questions of constitutional interpretation, people who might not otherwise have had occasion to think about those issues before. But he was also fun. He was fun. He was intimidating because he was such a big personality and so smart, but he was really fun, as you say. He sang in chambers and would spend time with us at lunch.
And he was one of the leaders of constitutional originalism at a time when it was first being introduced in the 21st century and 20th century. In what ways did his approach to the Constitution, to separating his political from his constitutional views, and to text and history influence you as a clerk?
Did. So originalism, for those who are unfamiliar, is the approach to the Constitution that maintains that the text should be interpreted as it would have been understood by those who ratified it at the time, or those who were informed observers at the time of the ratification of the text. And this isn't a new theory of constitutional interpretation. It's been with us since the beginning, but it didn't have a name. It wasn't a self-conscious approach, this idea of looking back to the founding generation and the state ratifying debates and Madison's notes of the convention and so forth. And it was really in the 1980s, and Justice Scalia was one of the leaders of this movement, that originalism became self-conscious and developed as a theory of interpretation rather than something that courts and judges just did. And Justice Scalia he wrote about it, he taught about it, he spoke about it, and he practiced it in his opinions. And it influenced me as a law clerk, but also as a law student reading his opinions. He used to say, he wrote a lot of dissents, and he used to say that he tried to make his dissents very interesting and readable because he wanted the law students to read them. And when you write separate opinions, you can speak in your own voice and you can say more about theory and your approach. And so he had opportunities to do that in his separate opinions. And those were opportunities to influence students like me.
Justice Scalia, weeks before he was nominated to the court, said that he'd had a dream where he was visited by Moses on Mount Sinai. And Ed Meese had just given a speech saying we have to look at the original intent, President Reagan's Attorney General. But Justice Scalia said, Moses said to him, don't look at the original intent, it's the original public meaning. And he decided to become a champion of that approach. To what degree do you favor original public meaning over original intent, and what's at stake?
So I favor original public meaning rather than original intent. And I'll give you an example that I give in the book that highlights the distinction between those two. So some people say, you know, if you're asking, well, what was the original intent, say, behind the free speech clause? That requires you to think your way into the mind of James Madison. You know, we had a case a couple terms ago that involved Snapchat, a cheerleader who posted some things on Snapchat and, you know, whatever social media you want to put in there. Facebook, Instagram, X, Blue Sky, etc. What would James Madison think about Snapchat? Well, that's the kind of question that really can't be answered. I say in the book, for those of you who have seen Harry Potter, when Dumbledore is over that sieve with all the memories and he's trying to whisk them out, that's what it reminds me of. It's not an exercise that can really be completed. But even apart from that, who cares? I mean, who cares what James Madison would have thought about Snapchat? Because James Madison's private intention is not the law that governs us. The Constitution is law. It has the force of law because it went through the prescribed process. It was ratified by the necessary number of states. And so what matters is what those who are governed by this law and those who would have made it law through that process understood it to mean, as the words at the level of generality at which they're written mean. And free speech is broad enough that it encompasses the communication of ideas. So at the time that text was ratified, so in 1791, that might have applied primarily to pamphlets and newspapers, etc. But if we're looking at what it means to communicate ideas, that can just as easily happen on Snapchat, on cable news, or anything else.
What do you do when you're looking for the original public meaning when the framers disagree? You note that so many of our constitutional debates go back to that original debate between Alexander Hamilton and Thomas Jefferson about the Bank of the United States. And you note that Hamilton wants to construe the Constitution liberally to find a power to charter by the bank, and Jefferson to construe it strictly, not to find the power. Completely different approaches to the meaning of the necessary and proper clause. How do you choose?
That's such a great question. And in this debate between Hamilton and Jefferson, as you well know, Jeff, about the bank, part of it turned on how do you interpret the word necessary? Necessary can really mean strictly, you really need it. We need water is necessary for survival, or it can mean beneficial to, helpful. Can have a broader meaning or a narrower one. Jefferson wanted the narrow reading and Hamilton wanted the broader, and Hamilton, his view carried the day. It's not easy to interpret the Constitution or any text, frankly, for precisely that reason. Words are often susceptible of multiple definitions. And so you look and see the answer isn't necessarily always clear, but Hamilton's view carried the day. As a matter of precedent, in McCulloch versus Maryland, the Supreme Court signed off on Hamilton's view. And the best that we can tell from the time, it seemed like that was the view that was predominant. So a lot of these things are educated guesses. Maybe that sounds too loose. You do the best you can with the materials that you have. But there certainly were debates at the time, and those debates repeat themselves even today. But when there are multiple possible definitions, you look at the one that seems most likely, and the one that carried the day there was Hamilton's.
I'm so excited to be about to put out this book on how the Hamilton-Jefferson debate defines so much of American history. And I was struck that on the court, the big debate over time has been not between originalism and non-originalism, but between liberal and strict construction, between the Hamilton and Jefferson approach to the Constitution. Justice Scalia famously called himself a Hamiltonian, a liberal constructionist when it came to congressional power, and Justice Thomas, I think, is a strict constructionist. Which are you?
Well, Justice Scalia also said, I don't construe text strictly, and I don't construe it liberally. I construe it at the level of generality at which it's written. So I don't come to the text with a preconceived notion of whether I should try to be, because I don't think I should be trying to tighten it or narrow it or read it expansively. Some clauses, like the president shall be at least 35 years old, are very specific, and you can tell exactly the level of generality at which they're written. But I think otherwise, I don't come with a preset, with a default setting. I don't have a default setting, Jeff, is I guess what I would say. Not strict and not liberal.
And does the original public meaning tell us which to be, strict or liberal, or does it instruct us to choose the level of generality that the people at the time of ratification would have chosen?
I think the latter, because I think, the Constitution it's comprised of clauses that were written at different times. And it's comprised of clauses that each accomplish different things. And so I don't think one level of generality, it can't be one size fits all, just because each clause taken in its context, the problem that clause was trying to address, the debates surrounding that particular clause, I think some clauses will have narrower and some clauses will have broader meanings when you're looking at competing possibilities like, is the word necessary narrow or broad?
And what do you do when the framers and the public change their mind? On the bank, Madison famously originally sided with Jefferson and wanted to strictly construe congressional power and strike down the bank, but he changed his mind as president because Congress and the people had accepted the constitutionality of the bank, and then he signed the bill rechartering the bank in 1814. Is it relevant to look at post-ratification history, which may, I guess the fancy word is liquidate the meaning of the Constitution in ways other than the founders and the people originally intended?
Yes. So actually, I since you went with liquidation, I'll go there too. When you asked me about how do we know whether Hamilton or Jefferson won the day, this idea that Madison had about liquidation is one way in which text that's susceptible of multiple different meanings gets distilled. Because over time, some text is a little bit more open-ended, and so it's the repeated interpretation which becomes adopted by people. Like the choice made here was for the broader interpretation of the word necessary. And so Madison said, listen, that meaning has been liquidated over time. In the beginning, I thought it should be the narrower, but repeatedly Congress, the Supreme Court, the political process has opted the other way. And so it's been liquidated. The meaning has been settled by the political process over time. And so Madison relinquished his view.
And this raises the important question of post-ratification history. In your, I'll call them wonderful because I just taught them at GW Law School last week, wonderful opinions in the Bruin and Rahimi cases involving gun rights. You have separate concurrences where you expressed some hesitation about using post-ratification history and tradition the way the majority did. You said that we don't want to assume that legislatures at the time exercised their regulatory power to the maximum, so we don't need traditions of regulation to justify them. And generally, you said, when it's construing constitutional text, you want to look at history around the time of ratification, not a kind of free-floating wide-angle lens. Tell us more about those opinions and your views about the appropriate use of post-ratification history.
Yes. So as Jeff and I were just discussing, Madison talked about one way of using post-ratification history, which is this concept of liquidation that I just discussed. But you always face this problem of what to do with our history. So originalism looks at the founding or the ratification era history in order to determine, if it's possible to determine, the meaning of the words that are used in the Constitution. But then a lot of stuff happens after that, right? You know, so the Bill of Rights was ratified in 1791, and here we are several centuries later, and we're still using the Bill of Rights. Fortunately, I wish we could see, you know, see out to, yeah, independence, all the First Amendment.
Yeah.
But in any event, I don't want, not what I think, that history and tradition means nothing. I think history and tradition means a lot. And one thing I try to communicate in the book is that the Constitution ties us together, and the traditions of the Constitution, including those that happened after ratification up to the present, matter a lot to defining the law today and the people whom we are today. But I think when it comes to figuring out what the force of law is, I think it's a mistake to say, well, if we're talking about a text that was ratified, say, in 1791, the way people did it in 1840, just to pick a random time, that distills it, and so then we're stuck. I guess I think using history and tradition, I won't get entirely into the weeds because I don't want to lose you at, you know, before we're at the halfway mark. But I think it's complicated, and we should never be relying on history just for history's sake. I think the strength that history plays in any kind of legal analysis matters.
Well, thank you so much for geeking out together, because these are the central questions of constitutional interpretation. I know all of you are listening closely, and Justice Barrett is describing differences in approach to history and tradition among members of the court that have great consequences for constitutional interpretation. You note in the book that history and tradition, there's the most consensus about using it when you're identifying unenumerated rights. And in your description of the Dobbs case, you embrace the approach that the Supreme Court had taken in a case called Glucksberg that said that when you're trying to define unenumerated rights, you define them at a modest, a constrained level of generality that's rooted in history and tradition in a specific way. Is that an approach to history that you think that there is broad consensus about?
So as a matter of our doctrine, Dobbs interpreted the Due Process Clause of the 14th Amendment, which says that no person shall be deprived of life, liberty, or property without due process of law. And Jeff was just alluding to the distinction between unenumerated rights and enumerated rights. So an enumerated right would be, say, the First Amendment, because our freedom of speech, our freedom of religion are expressed in the Constitution. They're identified. The unenumerated rights are housed in that word liberty in the Due Process Clause, and those are not spelled out. And so the trick then is, how do we know what rights are encompassed within the word liberty? If we are to have a democratic society in which we are ruled by the rule of law, and not just what 9 justices in Washington, D.C. think, we have to be able to root any constitutional guarantee in the document itself. For this reason, once a right is ratified, it constrains the democratic process. So take freedom of speech, for example. We hold statutes unconstitutional. It's tricky, for example, for Congress to regulate social media or to regulate porn on the internet, all of these kinds of things, because of the guarantee of the First Amendment, freedom of speech. Returning to liberty in the Due Process Clause. It would be very easy, we all value liberty, and it would be very easy, we could all come up with a list of freedoms that we think are central to liberty. But in order to say that something is so central to liberty that it has constitutional status and then constrains what any legislature can do, there has to be some basis for doing so, so that it's not just the will of the Supreme Court, but rather reflective of the will of the people. And our precedent, this case Washington versus Glucksberg, says that in order to identify any right as an unenumerated right that is protected by that word liberty, it has to be deeply rooted in the history and traditions of our people. And it has to be stated at a level of particularity for what it is. It can't just be freedom or liberty, because that would be kind of no limit at all. Because in this area of unenumerated rights, the way that I put it in the book is that it's the court's task to figure out what the people have agreed upon in the Constitution, not tell them what they should agree to. We might have ideas about what it might be good for people to agree to, but the point is a backward-looking one, to see what the Constitution itself actually represents and ratifies as what the people have already committed to.
And in the book, you say that this means that there are some unenumerated rights that the people have agreed to, even though they're not written down. And you give the example of Griswold versus Connecticut, where Connecticut was the only state in the Union that banned the use of contraception by married couples in the 1960s. You say that was not the case for the right to abortion, but you do believe that there are cases where historical consensus can codify unenumerated rights.
So Washington versus Glucksberg and a series of Supreme Court precedents going back to some cases dealing with parental rights in the early 20th century. The court has long interpreted the Due Process Clause this way. And so I describe that line of precedent in the book, and it is, as Jeff has said, that Due Process Clause, in summarizing that line of cases, Washington versus Glucksberg says that yes, the Due Process Clause does protect those unenumerated rights that are part of the deeply rooted histories and tradition of the American people.
Well, this is a wonderfully helpful seminar. Thanks to all of you friends for jumping in with us as we went to, the advanced con law version. But just so I can restate it, so I have it straight in my head, and I can also share it with you and my students, Justice Barrett is accurately describing the consensus view about history and tradition that the court has adopted over time, which is to use it to identify some unenumerated rights when they're specifically described and deeply rooted in history and tradition, but not generally to use it as a free-floating license to identify the scope of permissible regulations or to use post-ratification history that is not rooted to text, if I've got that right.
Yes, that's
great.
Precedent.
Well, we jumped into a sort of advanced originalism because of Justice Scalia and your clerkship. You tell us in the book why you're an originalist. Why are you an originalist?
So I think when originalism first became a self-conscious approach to constitutional interpretation in the 1980s, a lot of people talked about judicial restraint. And the idea was that there were more free-floating approaches that were less focused on the text and the meaning of the text, and that gave judges too much power to say, this is how these are the rights that we should agree to. This is the version of the just society that we should have, but without attending to the text as it was actually ratified by the people. I am not an originalist because of judicial restraint. I think people have accurately pointed out that there really isn't any method of interpretation that can sufficiently restrain a willful judge. And if anyone wants to tell you about that one, I can make some money quickly by selling you lots of other things too. So I'm not an originalist because of a theory of judicial restraint, although I do think attending to the text is a restrained approach to judging. I'm an originalist because I think it is the text that is the law. The text that we've ratified is the law. The Constitution, the Declaration is a beautiful document and an aspirational document, but it doesn't have the force of law. And so the Declaration is distinct from the Constitution in that respect. The Constitution is also a beautiful document, but it's not purely aspirational. It does carry the effect of law. And to apply a law, you have to know what the law means. And to figure out what the law means, I think you have to understand what it communicated to those who adopted it, who would have been part of informed observers to the process, not necessarily even the ones who would cast the votes. But it's because it's law. That's why I'm an originalist. It's
a very candid and powerful response to the critiques of originalism as it's been applied recently. It was originally presented, as you suggested, as a defense of judicial restraint, defined as deference to democratic legislatures or ways of constraining judicial discretion. But you note accurately that it doesn't really constrain judicial discretion in the face of a willful judge, because text and history themselves are malleable and you can invoke them on behalf of any argument you like. But in the end, you are applying it scrupulously, in your view, because the text is law and your job is to apply the law.
Yes.
Great. Well, then we've covered chapter 3, or the part 3 of the book. Why don't we just pull back now that we've done the really intense parts? And
Well, I should add here that Jeff is way more sophisticated than the book doesn't even go this deep. So you have had the benefit of Con Law 400 instead of Con Law 100.
Not at all. It does indeed, and explains things so clearly. The first part talks about how the court works, which is, of course, what everyone wants to know. And you say all sorts of interesting things about the way that you approach the job, including the fact that you, before you reach a decision, like to change the plaintiff and imagine that someone else is winning, just to make sure you'd be comfortable with the result as a legal matter. On those grounds, you also talk about how you engage your law clerks, who sometimes will do first drafts, but you'll often start from scratch after you get them. And your goal is always to, and you wait to read the bench memos until after you've read the briefs, because you want to be open-minded. Share more with our friends about how you approach the job of being a justice.
I think it's important to be, I think it's as important, as Jeff said, so I'll use the word that he used, to be neutral. I want to be dispassionate. My job is to apply the law as it is, not as I wish it would be. But judges are human. And so, Jeff began by referencing the line of my dad's that I quote in the book about control your emotions or they will control you. I think it's helpful to have some safeguards built in to try to keep myself honest and to keep me focused on the law. So one of those things that I do that I find helpful is if we have a case involving a policy that I dislike, I substitute in the opposite policy, because the law and the right result in a case, it can never turn on, as Judge Silberman used to say, whose ox is being gored, because decisions become precedents for tomorrow. They're not just trains that are for the one policy only, this ride only. So for example, there's a case in which John Marshall, who was an Adams appointee, had to decide about a subpoena that was served on Thomas Jefferson. And this was in the Aaron Burr trial. Could Jefferson, who was president, be subpoenaed? And Marshall said yes. That case was cited multiple times within the last 5 years. It matters. And so what we say about President Biden or President Trump is going to matter several presidencies from now, just as what John Marshall said about Thomas Jefferson continues to matter. So, for example, if there's a regulation or a statute or a policy that I don't like, I imagine, well, what's going to happen when this very same question of, say, congressional power or presidential power comes up in another context with another Congress or another policy or another precedent, because the legal issue will still be the same, and I will have to abide by this decision, this precedent, even when I might like the thing that's being challenged. And I find that to be a very helpful way to think. And yes, my law clerks, and this is mimicked from Justice Scalia, I like my law clerks to push back. We debate the cases. We try to figure out, what the weakest points are, and I want them to push back, because my job is to get it right. And to get it right, I don't want to be surrounded by a bunch of law clerks that just say yes, yes, yes. I want them to really tell me what they think.
And you believe that until you write it, you don't know exactly what you think. It doesn't write, is something that judges often say when they find that they can't commit their views to paper. You do the first drafts longhand because you don't, you think that the typing encourages too much revision and you want to get a first draft down. And you don't like adverbs, you tell us as well. And you have a very crisp writing style.
I think adverbs can be very, very, very illuminating.
Absolutely.
I tend to be very spare in my writing, and Jeff is referencing a story that I tell in the book about Judge Silberman saying, Amy, don't be afraid of the adverb. I find that when I write, I like to be as concise as possible. Maybe that's the teacher in me. I feel like when you distill an argument down, I think of it as almost like reducing a fraction. When you present it in its purest essence, or strip it down as bare as you can, it helps the reader be able to really follow the structure of the argument, because there's not a lot of other stuff that's mixed in that might distract from the essential argument. So that is the way that I write. When Jeff is referencing this phrase, the opinion wouldn't write, that just means that you think about, and judges sometimes say this, that the opinion wouldn't write. That means you debate it, you talk about it orally, you read the cases, and you know the path, you know what you think about how the case should come out. But then sometimes when you sit down to write it, you realize that the analysis doesn't hold up. On rare occasions, that might actually cause you to reconsider your vote in the case, about what the results should be. More often, I find that sitting down to write a case, to write an opinion, makes me think, maybe this particular path, or maybe what I thought about what this case was going to say, now that I'm really in there trying to write the argument out, I realize that doesn't quite work this way, that this is the stronger argument. So sitting down, I think lawyers will recognize what I'm saying when I say that sitting down to actually write an argument out is really the trial by fire to see if it actually works.
Speaking of the opinion doesn't write, you note in the book criticisms of the shadow docket, where the court is deciding cases without writing full opinions and instead issuing orders. Some of your colleagues have criticized the use of the shadow docket and say the court has an obligation to give its reasons. Yet you note that not committing yourself to reasons too early may preserve flexibility. What is your response to the criticisms of the shadow docket?
So I like to call it the emergency docket rather than
Sorry,
the
forgive me. Of course, the emergency docket.
Excuse me. So the emergency docket, that's where these orders, these emergency applications come up while cases are still in progress below, and they ask the court to either stay or enjoin particular actions to set a default while the case is being played out. And so, as Jeff says, the court has to make a decision. These cases don't come up the normal merits pipeline where we have, with the process I describe in the book, where we read the briefs and we have argument and I debate with my law clerks and then I discuss with my colleagues and we write opinions, circulate them internally, justices comment on one another's drafts. In the emergency docket, it's very fast moving. You get motions and you get applications and responses, but you don't get full briefs. And unless, and we only do this in rare circumstances, we have occasionally conducted oral argument on an emergency application, but that hardly ever happens. That's just not how these cases, the emergency applications, the point is that they're fast moving work. And then this isn't the final resolution. This is just an interim call. This just says, for now, during the interim, while this case is being litigated, this, say, regulation should have effect and, the administration can continue to enforce it, or it should be stayed and the administration cannot. And as Jeff says, there's a question about whether to write opinions or just issue orders. So, historically, the emergency docket has been accelerating over the last, I would say we started seeing more of these kinds of cases during the Obama administration, and they've accelerated in subsequent years, and we have the most, I would say, right now. Writing an opinion at the emergency stage or the interim stage is a complicated decision to make, because I do think, and I say in the book, that if you write an opinion when something is in this kind of preliminary posture, it risks a lock-in effect because the court's not making a final decision. Oh, I think I lost my mic.
There you go.
We're not resolving a case finally. We're just saying it's a kind of a for now. This is our best judgment about the merits, about the likelihood of success on the merits, and then you're considering other factors too. The emergency docket also considers things like irreparable injury and the balance of equities, and definitely getting into an upper level seminar here, so I won't go too far down the rabbit hole. But if we write a big opinion on the merits, when the case actually does come to us on the merits, I think it might leave the court a little bit less room to move. So I think writing an opinion isn't always the best course. I think it also, to write an opinion on which you can get a majority, 5 people agreeing, takes time. I describe in the book on the merits docket that the process can be very arduous. You know, you've got a lot of cooks in the kitchen. And when you're trying to write an opinion that, you know, garners the agreement of 5, 6, 7, 8, or 9 people, you know, that can take time. It takes wordsmithing, et cetera. And the point of the emergency docket is to move quickly. And so it can be difficult to reach that kind of agreement on the short time frame that we have for these quick moving cases. So it's not an easy answer. On the one hand, transparency is good. And so I think people want explanations, and I can understand that aspect of it. It's not all upside, though. You know, there are these countervailing concerns going the other way.
The sharpest criticism of the use of the emergency docket came from Justice Jackson, who said in a recent decision that this is a kind of Calvin ball jurisprudence. There are no rules, to which she adds, the administration always wins. What is your response?
Well, the administration does not always win. You know, I think that the decisions on the emergency docket, each emergency docket application, just like each case, requires justices to give their best judgment about how the factors in the law applies to the decision that we have to make. And people will draw different conclusions. Cases don't usually get to us unless they're difficult. And litigants don't usually bring cases to us that are futile. I mean, the cases that come to us are cases that are susceptible to 2 sides. That's true on the merits docket, and that's almost always true in the interim posture as well. So I think there are disagreements about how to see things on the merits, but it's certainly not the kinds of situation in which anybody has a default setting that, you know, one side or another should always win, or that the other side should always lose.
You and Justice Jackson have had a couple of exchanges in recent decisions. You've talked about the need for arguing without quarreling. Are these exchanges within the historical norm of the kind that Justice Scalia used to have with his colleagues, or do they represent an unusual level of polarization?
Oh, so Justice Scalia used to say, I don't attack people, I attack ideas. And if you can't see the difference between the two, you've got to get another job, because being on a multi-member court necessarily involves debates about ideas. And so I have debated ideas with Justice Jackson and with many of my other colleagues as well. You know, the case in which you were asking me about history and tradition, I was going back and forth with Justice Thomas. So that's part of the job. When you have 9 people, I just said it's like herding cats, you know, to try to get people to agree, but then even to go back and forth about topics on which you disagree with your colleagues. You know, that is a battle of ideas, but it's not personal. It's never a personal attack. And I feel very passionately, and I say this in the book, and this is how I conduct myself both in writing and in person, that collegiality and civility is crucial. I think it's crucial, and we observe it on the court. And I think it's crucial to our surviving in society and to our job as Americans to be living as citizens, as co-citizens, in this country, that it's our responsibility to steward. At the court, we have many long-standing traditions that cultivate this collegiality. We shake hands with one another every time we go on the bench. We have lunch together after every oral argument and after every conference. And speaking of control your emotions or they will control you, I was told early on that the most important days to go to lunch are days after conference when there's been a difficult vote, because those are the days when you don't feel like going. But those are the days where if you don't go, it lets that, lack of collegiality or resentment fester. And so I firmly believe, with all of my colleagues, that civility and warmth and friendship should always be front and center. And debates about ideas don't change that.
And you manifested precisely that spirit when Justice Jackson joined the court, and you heard she was a fan of the Hamilton musical, and you had performed a selection from the show, confirming the centrality of Hamilton to all of American history. I actually note that example in the Hamilton book as well. Well, this leads to, I guess it's your part too, but it's exactly the right place to end, which is what you want Americans to know about the Constitution. And you've just drawn a connection between personal self-government and political self-government, and suggested that the framers thought that controlling your emotions was necessary for democracy to succeed. And that was why they believed that only virtuous citizens and virtuous leaders could keep the republic, because if we descended into our basest passions and anger and jealousy, we would become like the mobs that felled Greece and Rome. So tell us more about why you are so convinced that the Constitution requires us to study and practice the habits of civil dialogue.
So I think there are so many aspects of modern life, and as the parent of teenagers, I can see this on social media, that cultivate incivility and that cultivate a real bitterness and hatred. And I don't think that we can live, virtue is a far higher baseline, right, than even civility and cooperation and working together. If we don't work together and cooperate, then our government won't function. And I think in each of our individual lives, not everybody serves in some official capacity in the government, but everybody serves, every citizen serves in the capacity of American. Everyone serves in the capacity of neighbor, of friend, of family member. And that's where change can begin to happen. That's where we can govern ourselves. That's where we can say, I am not going to see my neighbors and the people in my class and the people with whom I work as my enemies, but rather as my friends, so that we can work together towards common goals. Disagreeing, yes. Disagreement doesn't mean enmity, and disagreement need not mean hate. Disagreement should be about ideas and not about people. And I think the Constitution gives us ways to channel disagreement. It tells us how to govern ourselves through the process of making legislation. If we don't like the Constitution, if we feel like the Constitution is too big a constraint, we can amend it. And people talk about how amendment is impossible. We began by talking about my great-grandmother. The Constitution was amended 10 times in her lifetime. She died in the 1950s. We can, as a society, if the Constitution has become unamendable, the problem is with us. The problem is we are not able to cooperate together to compromise. And so I feel very passionately that we as Americans need to look at what unites us, and the Constitution is the thing that we hold in common. We have different creeds, we come from different backgrounds, but we hold the Constitution in common as Americans, and so it can be the baseline for us to move forward and to continue to build upon the history and traditions of our past.
So beautifully said. We must view our fellow citizens not as enemies, but as friends, as you just put it. That's why
Lincoln put it first.
As Lincoln put it first, I am loath to close. We must be friends. And that's why Jefferson puts a bust of Hamilton across from his own in Monticello after Hamilton dies. And when he's old, he passes the bust and says, opposed in life as in death. And he views Hamilton not as a hated enemy to be destroyed, but as a respected opponent to be engaged with. And that's just the spirit we've got to get back to. Are you concerned with the polarization that is afflicting America, and how can studying the Constitution help us to overcome it?
I think one thing that studying the Constitution helps is when you look at the Constitution in its context, when you look at the Constitution in its history, the history of America is reflected in the history of the Constitution, from Reconstruction, the Reconstruction Amendments, our recovery from the Civil War, from Brown versus the Board of Education and desegregation, to the New Deal. When you look at what was happening in America and you look at the ways in which the Constitution was amended to accommodate that, the cases that the Supreme Court has confronted as the political branches and the states tried to work up, find solutions to social and economic problems, we can see that we've been there before. I think the Constitution is a continuous thread. It not only binds us to one another, as I said a moment ago, but it also connects us to the past. And I think when we study the Constitution and we look at the document that has been America's foundational document for more than 2 centuries, we can see what we have survived in the past, what we have overcome in the past, and that gives us confidence, and it gives me confidence about what we can overcome and what we can do in the future.
It sounds like a passionate case for the importance of studying history.
For the importance of visiting the National Constitution Center.
And reading the interactive Declaration of Independence. History is complicated, and to engage people, you have to tell stories. Ken Burns is America's great storyteller, and he believes in telling the story in all of its complexity so that we can learn from the past. On Constitution Day, what are some of those constitutional stories that you want Americans to learn so they'll be inspired to learn more?
Oh, wow. There's so many. So now, Jeff, you're putting me on the spot. I think what I will do is I will end with a story that I tell in the book. It's not directly about the Constitution, but it's about one of my constitutional heroes, Chief Justice John Marshall. And I think that this story captures a theme that I hope that I've been conveying about civility, collegiality, humility. So John Marshall is known to history as the great Chief Justice because he really solidified the independence of the Supreme Court and established it as a co-equal branch. And John Marshall lived in Richmond. He would go back and forth. Back then, the Supreme Court did not sit year-round, and so he would be in Richmond with his wife. One day, he went to the market, and on the way home, a neighbor asked him if he could press him into service to carry home his items that he had purchased at the market, not recognizing he was asking the Chief Justice of the United States to do this. So Marshall obliges. He carries the man's basket home to his house, and the guy is humiliated when he finds out that he had, asked chores of the Chief Justice of the United States. And John Marshall says, "Well, I was going the same way. It was the neighborly thing to do." That was his response. Rather than trying to lord it over him or stand on the prestige of his office, he was humble. I think we could all use a little humility. And I think repeatedly through time, through our constitutional history, through our presidential history, we have seen public servants who have had that quality. And I think it is one that we could all stand to emulate.
Justice Learned Hand on one of the earliest Constitution days said the spirit of liberty is the spirit that's not too sure that it's right, that spirit of humility. for inspiring us to learn about humility, American history, and the U.S. Constitution. Please join me in thanking Justice Amy Coney Barrett.
Thank you very much. Thank you. Ready to go? Thank you.